welcome back. I know you wanted to comment, Professor Woolman's point.
Well, Dennis, to put it in more context is that we can't review how the judiciary has performed over the last 20 years without realizing and contextualizing the role of the judiciary within a constitutional dispensation that was negotiated in 1994. And the founding values of our constitution are indeed to ensure that all South Africans, all citizens of this country have a better life, to steal a phrase. And those are set out in the constitution. It's from equality, the right to vote, and substantive equality, including socio-economic rights. And so there are two players, in fact three, in terms of our constitution, which is the legislature, the executive.
They've all got to do something.
They've all got to do something, and the judiciary is there to ensure that all the other arms of government are held accountable, in particular the executive. And so the failure of 20 years later, that there hasn't been substantive equality as envisaged in the Constitution, is not the failure of the judiciary. In fact, the judiciary has done very well in advancing the causes of the poor who have found it ultimately necessary to go to court to enforce those rights, whether it's on health, TAC, on housing, Grootboom, etc.
Well, let me then put the following to you on this. I think that what happens when the courts, perhaps let me contextualize, taking the point that both you have made, this issue that the courts now become a last resort, because obviously people go to the courts in circumstances where perhaps the local authority or the provincial authority or wherever it is not providing for them. And then the courts come under more pressure. So we've had many instances, for example, of the politicians complaining about the courts. Just to give you one, the President Zuma talking, I think at a conference in 2011, said political disputes resulting from the exercise of powers that have been constitutionally conferred on the ruling party through popular vote must not be subverted, simply because those who disagree with the ruling party politically and who cannot win the popular vote during elections feel other arms of state or avenues to help them co-govern the country. There's a sense here that he's saying, and he's not the only politician, politicians all over the world say this, the courts must stay out of our business.
Yeah.
Now, if you get a situation whereby maybe because the bureaucracy and the administration isn't capacitated sufficiently, maybe the legacy of the history, all sorts of reasons, but when the courts are asked to do more, does that not put them under much more political pressure? And isn't that a problem for 20 years going forward? Are you, as a lawyer, not worried about that?
Well, I mean, we should be worried. In fact, I've said in some of the writings that I've done that there is always going to be a danger of the judicialization of politics or the politicization of the judiciary.
Yes.
If the executive start to do things which in their very nature are in themselves militating against the enjoyment of the rights that the ordinary citizens are entitled to, and every effort is done at a political level through their political representatives at the council level and everywhere, all efforts that the people are trying to do in order to redress, in order to, to enforce their rights, are simply kicked in the teeth. Then the courts become the only resort. The only resort for people to go to say, we've tried everything. But we want services, we want education, we want this, we want that. And every time we've gone to the politicians, whether at the local government level, we have not met with any joy. And therefore the courts become the last resort. And
hasn't there been a politicization a judicialization of our politics? I mean, I can't help but mention that in the now, we read that there's going to be a challenge to the public protector. Again, the courts are called in to what has become a very fraught political question about Nkandla. The courts are going to have to deal with
precisely because, I mean, look, the politicians have now taken what is patently something that should be dealt with in Parliament. They've taken it to the courts.
Yes.
Now that's the kind of danger that we are running.
It should have been dealt with in Parliament.
It should have been dealt with. In fact, it is in Parliament.
Yes.
And there is every reason for anybody to then say, oh, wait a minute. This is another attempt to avoid another, organ of state, another arm of government having to perform its duty. And therefore, there must be an editor in that kind of conflict.
Well,
that's what the courts are there for.
See, and that's my anxiety. That's what Adv Ntsebeza has put has given.
Too much pressure.
Is that if you have failures, whether it's a political failure because of a controversy such as Nkandla, which is what we're talking about, but if it's socioeconomic rights where government may well say, sorry, we can't do this for the following reason, we've got foreign investors, and Lord knows what, people come forward, courts say, sorry, you've got to do that. There's a sense in which there's a resentment. It's not just South Africa. Coming from America, that there are huge difficulties where courts are over-politicized. But in a fragile democracy, i.e. not fragile in the sense that we're going to collapse, but a young democracy, that's the better word, those are greater dangers.
Right.
So and how do we deal with that?
I think the court's been pretty good. Let's take the public protector. The case I first referred to when I talked about state building. They said the new text, not good enough in terms of the protections afforded the public protector. You need special majorities for removal, right? They protected the public protector's office then because they understood it was important to the proper function.
Now.
And I think the court can, well, look, just a couple of years ago, they handed down Glenister, which said quite bluntly that Glenister will be back in multiple forms.
Yeah.
But the court had some gumption.
And the politician gets very cross about that.
Well, so what?
The question I'm asking you is
but hold on. The point in Glenister was the court said, look, we're supposed to have independent and effective security services. You gutted them by removing the scorpions and replacing with the hawks. We're telling you that's good enough, not good enough.
But what I'm putting to you is that, that's a terrible term. I do apologize for it. No, it's shocking.
Put it to me.
No, I'm not going to put anything to you. It's a shocking, terrible term. Let me ask you the following. No, it's my listeners who can't take it. Let me ask you the following. If, and this is I think what Dumisa was saying, if you get the situation that the courts are the last resort, right, I'm talking going forward, I'm not saying it's happening now, I'm saying we're looking 20 years forward. If the courts continue to be a last resort, then there's an imbalance in the society and in a sense, they're almost overcompensating for failures. The point he made now, that the legislature should deal with something, if you put it to the courts, that kind of makes the system rather wonky.
All right.
Why do you want the courts to do everything? So you can academics can write more articles.
No, thank God. No, thank God the Constitutional Court only hears 30 cases a year. If they heard any more, it would be too much of a burden for people like me. But that's the point. Actually, we're talking about the courts as if they're the last resort. But the truth is, one of the things that the Deputy Chief Justice said to me just a few months ago, one of his big disappointments is the level of access to the courts. The courts, in fact, if you're talking about our apex courts, aren't really playing that role because a lot of those. Let me make 2 points.
I want to ask.
Let me make 2 points. Those service delivery protests happen. Those 6,000 protests happen on the ground all the time. Those are political protests. They will work them out in political ways, whether the ANC.
You hope so.
I hope so.
But I want to come to... Sorry, I've got to stop you. Let me ask you this. The access to justice point is an important question. We surely can't be satisfied after 20 years that we've done well enough on that. For ordinary people.
We can't be satisfied. And
how do we change that?
Well, the legal aid South Africa has gone a long way to addressing the questions of access to justice. What we need to do going forward is to ensure that bodies such as Legal Aid South Africa, institutions of first choice for law graduates to cut their teeth at as lawyers, so that those institutions, Legal Aid South Africa and other law clinics, are able to afford poor people access to justice
I've got to run out of time.
through good legal representation.
I apologize to all three. I know they all want to say more. They should say more. I'm constrained by time, so let me simply say this. 20 years of democracy, I think what all the panelists have said is correct. There's a lot of cause for celebration. Perhaps we haven't celebrated enough in that sense. I mean, when we go back to 94, we talked to my two practitioners on my right here, my right in terms of in the studio. They talk about what it was like under the old days. We forget about that all too easily. We forget about what Professor Woolman says, the way in which houses have been built, in which people have had access to justice. But there are problems. There are problems about what balance is struck between the three arms of state, and how does politics interface with law, and if law is overburdened, whether that in fact has a cost, which 20 years from now we may say, gee, that has really caused problems which we could not have foreseen 20 years ago. How do we negotiate all those problems? Judge for yourself. Goodbye.
News that moves. enca.com.